Mr. Munger, you wanted to add?
On a few points which have been raised here. There's obviously a disagreement about whether the current language in SCA 4 does or does not guarantee that every legislator gets to read a bill before it comes out of their house. Allow me to show you the kind of concern that we have. We've only had 72 hours, of course, to parse this language, and the language is dense, but this is our concern. It is agreed under SCA 4, as it was submitted June 1, that it required 72 hours notice only in the second house. So if you're in the assembly and somebody takes a bill on dog catching, amends it quickly to a bill of criminal justice and shoots it straight across to the Senate, then only in the Senate would anyone pause for 72 hours and vote on it. The 39 members of the assembly who might have voted against the bill still had no chance to read it. And that was a problem. And I acknowledge that
That was correct.
that is right. That is now okay. Now we come to the new language in the current version. If you read it carefully, it says under certain rather complicated conditions, something may occur. And what will occur will be another vote in the House of Origin for the bill. And the problem is that the legislators who may not have had a chance to read the bill may not be in the House of Origin of the bill. How this might happen: a bill on dog catching in the Assembly might be passed with due notice to the Senate. In the Senate, it will be gutted and amended with zero notice and shipped across back to the Assembly. You have 19 members of the Senate who've never read this bill. It's now in the Assembly. It has to wait, according to the first rule, 72 hours for the Assembly to make that final vote. So they make their vote. And then we invoke a clause that says another vote must occur in the House of Origin for the bill, which is, of course, the Assembly for this bill, not for the Senate. So you still have 19 members of the Senate who are saying, I never read that bill before the vote occurred that had it dismissed from my house. So we have concerns that, in fact, one can operate the procedures in order to blindside a submajority of, in this case, the Senate. And if you reverse the roles of the bills, you could start with a bill whose House of Origin was the Senate and choose to blindside 39 members of the Assembly. We don't think, therefore, that this language adequately captures the intent that every legislator should always be allowed 72 hours in order to, before they're called upon to make a vote on a bill that might dismiss that bill from their House. So that is the largest matter we have. The other matter we have is, I frankly agree with Senator Nielsen, as a constitutional matter, if this legislature decides an effort is reasonable, if this legislature decides that sufficient funds are appropriated, what authority is going to tell this legislature that it's not? There's not a whole lot in the state of California and in our system that can overrule the California legislature. In fact, the only agency one can imagine would be the California Supreme Court. And I do not think that anyone coming to the Supreme Court with the legislature saying that we appropriated, yeah, some people say it should be $3 million for this or $1 million for this. We appropriated it to $50,000, but we think that's reasonable. I do not think a case ordering the legislature to direct more money is going to succeed. If the legislature said we made reasonable efforts to broadcast a certain meeting, I don't think anyone's going to be able to come back and say, well, the efforts weren't reasonable. While I applaud the efforts to try to put constitutional protections on this, the language basically says the legislature shall volunteer to make whatever efforts the legislature deems best, which is something that you can and do now. This meeting is being recorded right now. It could be live streamed. I don't know. Somebody can tell me, but these are at the discretion of the legislature now. So in fact, these constitutional provisions are not actually adding anything. They just give the illusion that something is now protected in the Constitution, which is and will remain in the hands of the legislature to determine.
Thank you. Thank you. Any additional, give me a second.
Please, of course.
Any additional questions? I want to make sure we get to members'
I
questions.
just
Senator
had
Hill.
the issue of reasonably accessible or reasonable, I mean, that seems, is that a legal term that has a particular criteria or standard? I mean, is it as subjective as it appears to be? It is, okay. Because it does, and I'm just looking at the part about related to the audiovisual recordings, and the recordings shall remain reasonably accessible to the public for not less than 20 years. And how do we deal today, and I don't know if anyone has an answer for that, how do we deal today with the accessibility to other documents? I mean, obviously, the Public Records Act and is reasonable a part of that discussion or that determination within that, or is it just, as we would say, that they would remain accessible to the public for not less than 20 years?
Again, Senator Hill, I just want to reiterate again.
Yeah, I know, we're talking about dollars and cents here today.
Right, right. Now, the other thing is, I just wanted to reassure you that under this initiative, under any hearing, whether there's an actual vote, whether there's an official action being taken, we are making that mandatory. This is for, the reasonable is the example of the select committees, which I believe some of those are actually recorded here in the building. But Senator Hertzberg, if you can respond to the reasonable.
If I could also, Mr. Chairman, just if I could, with respect to the issue of the bills coming back to the second house, it comes back for concurrence. If there's a gut and amend, it's not as if no one knows. It's a concurrence vote, and that's required between the houses. So clearly the whole issue of notice is otherwise met. And I know this isn't directly related to the jurisdiction of this committee, but I think it informs it given the questions of the committee members. In the last committee, there were, there's no doubt, I think what was indicated by earlier testimony, that and both of us have been deeply involved in this issue over the years and have not been successful. This has been informed by the initiative. The initiative that was filed had an impact on the legislature. That is the tension that often exists between the initiative process and the legislative process. The frustration that we had that we tried to fix, that this body voted under SB 1253, was when there is this tension, to give an opportunity, albeit late, but an opportunity for the legislature to engage and to fix it. Now, the point here is, and particularly with respect to what Senator Nielsen appropriately raised, is that what's before the voters, if this matter is qualified and goes before the voters that's currently there, that Mr. Munger is referring to, it has certain provisions. The things that we're discussing here are things that are additional points. In other words, what happened in these amendments over the last number of days has been how do we reach an accommodation to make sure we have an agreement on the 72 hours, on the language certainly is a violation of the law, the various points. These additional points about having these other hearings, about using technology to, technology pieces, live streaming, copyright, flexibility for remote hearings, ensuring of the funding, those have been additions to in an effort to improve upon what's before us. If this measure doesn't go forward and the initiative does go forward, there is no issue to which Senator Nielsen raises that's addressed by the initiative. It doesn't even consider it. It's all about the underlying architecture of the relationship between actions by the legislative branch of government and the people, not what happens within the rules. So all I was just going to share with you is, in the last point about reasonableness, is yes, there is standards in the law. The entire basis of common law is all about the reasonable person test. There's huge amounts of understanding of what constitutes that. Could it be litigated? Of course. There's no question. Just like any of these things can be litigated. But the reality is that what good lawyers are trying to do, in my judgment, by drafting it the way they drafted it, is to set a standard. They're adding on a whole host of new things that weren't initially, that aren't in Mr. Munger's measure. So I just wanted to share that with you. Okay.
Thank you. Additional questions? Senator Bates.
I'd like to go back to just a couple of points. One is the amendment and the concern over the amendment procedure. My understanding is if it's amended, it comes back to the House on concurrence. Are those amendments in print and available to the other House within 72 hours?
Yes.
So what we currently have on a gut and amend is if it's yeah, we all have a problem with that, right? And frankly, the initiative was addressing that. But what I'm concerned about is we're talking about the internet access. And and I know, and you're looking at somebody who doesn't use that. I use the print. And we've had a difficulty here this morning trying to figure out what the printed stuff says. What if we were trying to do that on the internet, when it's posted there? So I just want your absolute confirmation that when this is going back and forth in this one house issue that's been raised, that the other house is not having full access in print to whatever happened in the other house. And that remains a contention if I heard what Mr. Munger was saying in terms of his concern and opposition to this.
We believe our amendments meet that test.
Okay, well, I guess that remains a difficulty. With regards to the rules, we all have a problem with the way the rules can be weighed with the majority position. So for us to tell the public, that's okay, we have the rules, and maybe it doesn't get a policy hearing the way we would want it to happen, Senator Hertzberg, because the rules in that house don't require that, that's not good enough. I mean, that's one of the basics that's here in terms of what we're discussing of transparency and accountability. So that one doesn't pass muster for me. I think that that's why I would assume that the Legislative Transparency Act is a better way to go. And my last question I'd like to pose to, if it's approved by our chair, I'd like to ask the newspaper folks who spoke in support of the SCA 14 if they would also be supportive of the Legislative Transparency Act, because to me, it's a more perfect statement to the public about what I think the public wants to know about what we do up here.
Okay, first let's answer the first part of Senator Bay's question, and then we'll move to.
All right. First of all, it's important. One of the things that we did add in, because we did hear the concerns, was that the penalty for this is the bill doesn't become a statute unless it complies with what we believe to be is a clear 72-hour requirement.
In print.
Yes. So on the internet, posted on the internet. So, and in print. So,
Is that in the statute, in print and online?
No.
and it's,
It says.
The bill is passed
It
by-
says internet. It does not say in both cases.
in its final form for at least 72 hours prior to the final vote in the second house. So it's on the internet.
Okay, that should be changed.
Definitely, as it moves on to another, assuming it gets out,
Take a look.
take a look at that. It's gonna
Yeah,
have.
I'd just like to get your comments.
Uh,
We have two proposals here.
Thank you, Senator Bates. We had been working with Senator Blakesley and Mr. Munger on language of that initiative. Over time, they sought our counsel on several things. At the end of the day, however, my association has a position pretty much based on principle that the association does not engage in the initiative process, just because of limitations that our association sees as it being sort of a one-shot deal. You qualify something for the ballot, and you only get one shot to get it right. Whereas a constitutional amendment that's considered by the legislature has a process, and we're going through that process right now, where criticisms and opposition can be raised and changes can be made to make the ultimate language that goes onto the ballot for consideration by voters a much better quality thing. And so we are not supporting that for that reason, but it's not based on content, it's based on our ideological position on the issue.
Thank
Then
you.
it's based on process. That's what you're speaking
Yes,
to.
yes.
So you would be more likely to take a neutral position on either one if they hit the ballot together.
We have taken a neutral position on the initiative as it's being qualified right now, although some of my members have come out in support of it individually.
Okay.
But I have not yet seen any reaction to the SCA and AB 884 from any of our members, and it may very likely be that they'll support both.
Thank you. Any additional comments or questions? Senator Mendoza.
Mr. Munger, I know that your initiative is moving forward. Is there anything that can be done and what's being proposed right now or changed that would make you want to withdraw your initiative? Anything, I mean, because some of the parts here that we're kind of filling in some of the gaps that probably we're missing over there, but is there anything that could be possibly amended or changed into that might be more feasible for you? to support?
Well, that's why I'm here. As the process continues, obviously it's possible for me to withdraw an initiative if a legislative proposal is put on the ballot, with which I agree. It's even possible if this takes longer and it goes on the ballot, that doesn't mean that I have to campaign for my version. I can, in fact, campaign for a different version, which might be the version put on by the legislature. I'm here to engage. I and my proponent have the view that we're here to take what the CLTA would guarantee to the public in the way of transparency and say, first of all, we aren't going backwards on it. Okay, so we're going to be very careful on any language the legislature might offer, that we are very careful that if it's different language but purports to do the same thing, that it in fact does the same what we had. We had months to work out fine details of constitutional language. We don't want, out of good intent, but a little bit too hasty, to open a gap, which some court will find later, which will diminish the transparency. We're very interested in increasing the degree of transparency in the legislature. We've been careful not to lay burdens on the legislature that an unwilling legislature might not want to do. But if a willing legislature wishes, for example, to live stream a subset of its meetings, that's a definite improvement. We didn't lay that burden on you. We said you had to post things within 24 hours, but that's clearly more transparency. You could also say that for some or all bills that are of particular importance, you might say 72 hours is just not quite enough to go through them. I had exactly 72 hours from the new language on this, working through the weekend to assess it. I could understand that there might be a subset of bills that you would say, yeah, perhaps future things that go to the ballot maybe should have more than 72 hours. Perhaps urgency statute should have more than 72 hours. There are possibilities for taking particularly consequential bills and saying, let's be very certain we have those right, because particularly urgencies, because if an urgency statute passes, it can't be referended. The governor's opinion is irrelevant because a 2/3 vote passes it. Maybe a little more deliberation is in order. There are ideas in that direction. There are ideas and directions that we did not lay in the legislature, making these recordings not only available, but easily accessible and usable by the public. So if the legislature were to determine to be a really great idea to transcribe them so that the deaf can follow the proceedings some reasonable amount of time after the actual proceeding, if they were to be translated into Mandarin or Spanish, if they were to be cross-correlated with the agenda, if they were to be made searchable, if this were to be basically a marvelous top-of-the-line engine that allows any citizen not only the ability to play the hearing, but to find exactly the 5 minutes that is most relevant to them. All of these are things that we left to the legislature to work out. And if this legislature had in mind working them out, we would be delighted to participate in this sort of endeavor. But we wish to take what we have, the guarantees that we have, and move it forward. And one of the easiest ones that's not in this yet, but we really think has got to be there, is that if a member of the public comes here and comes to a public meeting, with any member of the public can attend and wants to pull out a cell phone or a camcorder or whatever it is, as long as they're not disrupting your meeting, they can make their own recording, because that way we keep the official recording complete and honest. And it's the case in all local governments, and it should be the case here. Thank you.
Thank you. Just some thoughts, whether we agree with this constitutional amendment or the referendum, the initiative, I think it's a healthy discussion to have on how we can improve transparency in our government and utilize technology to the best of our ability to ensure that we do have access for everyone in a way that I think is reasonable, in a way that definitely, if we're having an official vote or an official meeting of a body within the building or outside the building. So I think the conversation is one that merits further contemplation. And Senator Wolk, I know you, Senator Bates brought some important questions, and I think hopefully we consider those as well. And so if there's no other questions from committee, I will entertain a motion. This is a due pass recommendation to the Senate floor. There's a
Mr.
motion
Chair,
by Senator Hill.
I'd like to do a substitute motion, which is probably not appropriate, but I think it has merit. I believe that I'd like to move that that the bills go to suspense so that you can continue to work on following our discussion here, both fiscally and some of the policy discussions, there's time. I understand we've got a June 30 deadline. We're going to work ourselves very hard in the next couple of weeks. There's time, and perhaps we can get some consensus. So what we put before the public is something that we all think is going to do the job, that 1 million people wanted done, that signed the petition for the Legislative Transparency Act. I think that's our obligation to the people. We're here to represent them, of, by, and for the people. So let's try to put the best product out there.
Thank you. Senator Bates, a substitute motion is completely in order,
Okay.
although I don't agree with it. I think we'll have to actually have the process for it to go to the other house as well. So it is a timely issue, and I think having a discussion on both the initiative and the constitutional amendment will yield a better product, I think, on both ends. So Senator Bates has a substitute motion. Chairman is requesting a no vote. Our Vice Chairwoman is requesting an aye vote. Secretary, please call the roll.
Laura?
No.
Laura, no. Bates?
Aye.
Bates, aye. Bell? No. Bell, no. Hill? No. Hill, no. McGuire? No. McGuire, no. Mendoza? No. Mendoza, no. Nielsen? Aye. Nielsen, aye.
Substitute motion is defeated. Now the motion at the table is a due pass recommendation to the Senate floor. Secretary, please call the roll.
Laura?
Aye.
Laura, aye. Bates?
No.
Bates, no. Bell? Aye. Bell, aye. Hill? Aye. Hill, aye. McGuire? Aye. McGuire, aye. Mendoza? Aye. Mendoza, aye. Nielsen? No. Nielsen, no.
That measures out with a 5-2 vote. Now we have AB 884. Senator Gordon, please proceed.
Thank you, Mr. Chairman, Senators. If you've just heard a lengthy discussion on SCA 14. AB 884 is a companion measure that, taken together, will modernize the operations of the legislature in order to bridge the divide between the public and this legislature and our decision-making process. Currently our Constitution provides that the proceedings of each House of the legislature and its committees shall be open to the public. But very few Californians actually have the opportunity to come here to Sacramento to attend our hearings. These measures will make these hearings available to the public in formats that are retrievable and in many cases live streamed. AB 884 contains details of the implementation necessary for SCA 14. It provides a framework for how the legislature would arrange for the audiovisual recordings in a way that provides clear and unambiguous direction. Since this is the Appropriations Committee, and let me acknowledge that there will be some costs with this implementation. The one-time cost, as you've heard, for equipment could be in the range of $2 million, and ongoing costs of $1 million on an annual basis. These measures, again, were drafted to provide certainty without ambiguity. So we don't believe that the costs will exceed expectations. And we believe these are reasonable cost expectations. And in the end, AB 884 and SCA 14 would simply and appropriately narrow the distance between the lawmakers and our citizens, and I would respectfully ask for an aye vote.
Thank you. Witnesses in support.
Mr. Chair, members of the committee, Jim Ewert with the California Newspaper Publishers Association. We had a support if amended position on this bill when it was first amended several days ago. And the concern that we had at the time was the idea that the legislature had the ability to assert a copyright interest in the disclosure of information and the impact that might have on the Public Records Act. And not so much the ability to access the information, but more on the ability to use the information once it was accessed. And we're currently involved in opposition to another measure that's going through the process now on the very same issue. Much to our delight, the bill was amended recently to specifically address that issue. And not only is the footage that would be subject to disclosure going to be placed in the public domain, but all of the documents in that code section, including access to histories and other parts of the bill file, will also be in the public domain. And we think that strengthens the effort and ultimately strengthens the process, because the public can't really participate if it doesn't know what it is that the legislature is contemplating. And for this reason, we urge your aye vote. Thank you.
Thank you. Additional witnesses in support. Witnesses in opposition.
Thank you, honorable members. Charles Munger here again. I'm not going to go back over the policy issues that are tangled in this bill and the previous Senate bill. There's been an adequate discussion of those. I will confine myself to the fiscal issues of this bill. One of them I'm not going to address at all, which are the fiscal issues regarding this copyright provision. 72 hours is not enough to try to ascertain the costs associated with that, if any. However, I do want to address the costs involved in archiving the recordings and making them available on the internet. This is incredibly cheap. The previous bill may cost $1 or $2 million to give you the cameras, and it may cost you $1 million to actually have someone to run those cameras. But once you have the recordings, keeping them on the internet and keeping them in an archive accessible, the costs are essentially zero. Zero is a number you very seldom hear in these committees. Let me give you some examples. You can buy a 1 terabyte hard drive right now at Target for $90, which will store 2,000 hours of video. Okay? Finding a place to store every hour, every minute of every legislative public proceeding, which the CLTA does, or the subset, which this bill does, the costs are not at all important. We're talking about the cost of archiving them. We're talking about records of digital files. Normally, when you talk about archiving something, you worry about certain things. You're talking about media which are decaying, like historic documents printed on acid-containing paper. You're talking about a large mass of material which has to be sorted through. Somebody needs to be a librarian. Someone has to guide you to it. Someone has to make sure if you show up and use it that you don't steal it or damage it, et cetera, et cetera. We're talking about digital files on the internet. My estimates are that you can take all the digital footage for the legislature for an entire calendar year, go to a commercial firm and say, put this on the internet, and ask how much it's going to cost. It will cost less than it will cost you, the legislature, to buy the paper for your 120 copies that you looked at on the floor before you voted to approve the legislation. That's how cheap it is. So as far as the fiscal cost of this measure, again, I recuse myself from the question of copyright. They're utterly negligible. Thank you.
Thank you. Just let it be known, June 13th, I actually agree with Mr. Munger. Go ahead.
Thank you, Mr. Chairman, members. Good morning. David Wolf again with the Howard Jarvis Taxpayers Association, opposed to AB 884. And members, I'll be brief and simply reiterate, I think, a point Mr. Munger has made already. Article 2, Section 10 of the California Constitution states that an initiative statute approved by voters can only be amended by way of another ballot measure. AB 884 offers no such assurances at all that this can be the case, and nothing stops this legislature from coming back technically the day after SCA 14 is approved by voters, should it make the ballot, and make amendments and statutes to those provisions. And, you know, we just believe that the 12 days, as seen in SCA 14, is not at all sufficient to the protections offered by the CLTA in terms of being able to make amendments. So for those reasons, ask for a no vote.
Thank you. Additional witnesses in opposition? Comments from committee? Senator Bell.
Well, the whole audiovisual recording should be totally open and available to the public. And that's my opinion. I mean, you know, we're a public agency, and if we spend any money, we should be updating these ancient buildings that we have. We realize these are ancient buildings, and I hope someday all the state buildings that we have any kind of hearing will be facilitating anybody in California or the world to look and see what we're discussing, because I think we're discussing issues of great import, and everybody should be able to, at any time, see live streaming of that information. And quite frankly, I think if you had some kind of public-private partnership or some other kinds of way, it probably costs nothing. I don't know. I mean, that could be another way of looking at it. It probably won't cost anything, in my opinion.
Additional comments or questions for the authors? Senator McGuire?
Just as this bill continues to move forward, I know one item that many counties do is contract with their local media centers to be able to look at an inexpensive alternative to both digital media storage as well as the filming. And I'm not suggesting that we look at that on the filming, but it is a very inexpensive alternative, and a potential resource for that could be, once the state took all PEG fees away from local governments, potentially looking at those PEG fees to be able to help use to fund the digital storage of that as it was originally intended to do anyway.
I think the importance too is to stay technology neutral, ensuring that we allow new technologies to enter that, again, will cut the cost, which is already minimal, in my opinion. So is there any additional comments or questions?
Just a
Senator Bates?
closing one. A very interesting thing happened in my Senate district over the election. Two measures were on the ballot, one by the City Council vote and one by the people. The one by the City Council did not take into account the issues that the public wanted amended. Guess which one won? The one that the people had door to door, shopping center to shopping center, gathered signatures. It passed. And as we're concerned here, in an initiative form, it really has affected the opportunity to do something we all feel is very important in affordable housing without a vote of the people. Some of that is now part of their constitution, their charter. So I can't leave this hearing without urging that we take into consideration the opposition's concerns with what you're putting out there. Because I guarantee you, 1 million people become a very angry hornet's nest. And if we will not pay attention to the problems that have been raised in terms of responding to 1 million people who are talking about this, then I think we're going to be very disappointed with the outcome, and perhaps people like me are going to be more happy about it, but I think it needs improvement, and I think we can all agree to that, including the author. So I will have to oppose this one as I did the other, understanding that I know you're trying, Senator Welk and Assemblymember Gordon, but you got some more work to do. And or this it's not gonna get us where we want it.
Thank you. Thank you, Madam Vice Chair. Again, I think both the initiative and the constitutional amendment have really gotten us to a place where we're finally having a discussion about transparency. And I think there was some valid points brought up by the opposition that I think deserve and merit further discussion and dialogue. Again, the worry that I have is that in an initiative process, things change, technologies change, ways in we conduct our legislative business change. And so allowing for that flexibility to allow technology to continue to make our government more transparent, I think is important. And the way we do that also can change given technology. And so, you know, all I say is as somebody who's putting something on the ballot this November to change archaic pedagogy when it comes to English language learners, again, having to go through that process and not allowing new technologies, new methodologies to come in to the fray also kind of hinder that process. But I think the work that's being done to the initiative, the work that's being done to the Constitution, amendment, and the legislation, I think, continue to have a very important dialogue on how we better conduct business in an open and transparent manner for Californians. And so with that, I'm going to recommend a do pass recommendation for their second item, AB 884. Secretary, please call the, I'm sorry. Can we, if you guys, Senator Wolk and Assemblyman Gordon, would you like to close on the measure?
Let me just say thank you for this hearing, and I also want to sincerely thank the opposition for coming and being here. I think that all of us see this process as iterative and working towards the best level of transparency that we can get to make sure that our citizens understand what we do and are a part of the process and can inform us in our decision making. So respect the discussion. I think, will make us better as we move forward. And I think both of us are committed to continuing to work with the opposition as this moves forward, should this motion pass today. With that, I'd ask for an aye vote.
Thank you. Senator Walk, would you like to?
I would just like to thank the chair and thank the members for their suggestions, for their questions. We will continue to work on this. There were some good suggestions, and I think we can move forward on this. As someone who has been involved in this issue and has authored bills and co-authored bills, we finally do have a hearing, did we not? In fact, several hearings. I'd like to see us be able to move forward with one item on the ballot. I think that would be a beneficial service to the state of California. Ask for your aye vote.
Thank you. At this time, I'll entertain a motion, do pass motion to this in front. Moved by Senator Hill. Secretary, please call the roll.
Laura?
Aye.
Laura, aye. Bates? No. Bates, no. Bell? Aye. Bell, aye. Hill? Aye. Hill, aye. McGuire? Aye. McGuire, aye. Mendoza? Nielsen? No. Nielsen, no.
We will keep the roll open to allow our absent member to add on. Thank you. Appreciate your time. Thank you. Secretary, please call the absent members.
Mendoza?
So 4-2, the bill is out. We are adjourning our Appropriations Committee meeting for today.